Call the final case on the morning docket, 112053, in the matter of Laurel R. Kutzka. As council settles, I'll note that Judge Tony Powell has joined us on the bench. Judge Powell, thank you for helping us with this matter.
Pleasure to be here.
May it please the court, Stan Hasler, appearing for the Disciplinary Administrator's Office. Chief Justice Lukert, I would like to reserve 2 minutes for rebuttal.
2 minutes is reserved.
This is an original proceeding in attorney discipline as a result of a hearing that occurred in May of 2019, or August of 2019, I'm sorry. A brief statement of the facts. The respondent was admitted to practice in 2011, started as an associate with a firm in the Kansas City area. The misconduct occurred while the respondent was with the firm, and it was serious misconduct. There's no question about that. The respondent misled clients about the status of their cases. She fabricated court documents, including falsifying a judge's signature. And that occurred on 3 occasions, not the judge's signature, but 3 different instances where documents were created. Misled firm members about the status of the cases, failure to complete tasks for clients, and this happened in 18 different cases. The rules violated were competence, diligence, communication, truthfulness in statements to others, conduct involving dishonest conduct, conduct prejudicial to the administration of justice, and other conduct that adversely reflected on the respondent's fitness to practice law. The respondent did stipulate to facts and to rule violations. No exceptions were taken to the panel's findings by the respondent. And clearly we're here today to discuss what the appropriate discipline is. With respect to the recommendations made, the respondent has requested that she be allowed to continue to practice under her probation plan, which she submitted to the panel and to our office. She has filed an affidavit with the clerk indicating that she is in compliance with her plan, and I have no evidence to the contrary. Our recommendation, in the formal hearing report, it says that our recommendation is a 2-year suspension, and after 1 year, the respondent be allowed to just start practicing under a supervision plan. I think that's not correct according to the record. That's not the recommendation that we made at the hearing in this case. I think there's some confusion, but if you look at the very last page of the transcript in this case, you will see that we recommended a 2-year suspension, that the respondent be allowed to apply for reinstatement after 1 year, but that she should be required to go through a reinstatement hearing at that time. The panel recommended a 2-year suspension, and after 6 months of that 2-year suspension, the respondent would automatically be allowed to re-enter the practice of law, subject to her supervision or probation plan. The panel did find that probation was not appropriate due to the dishonest conduct in this case. So I would like to discuss from our perspective what the appropriate discipline is in this case.
Before you do that, one of the complaints is that the respondent falsified the judge's signature and a court stamped on the document. How did that happen? And you said that happened on more than one occasion, but there was at least one where the judge's signature was falsified?
That's correct.
And how did that happen?
A judge's signature was only falsified on 1 occasion.
And how was that accomplished?
I looked back through the record, read the record, and I'm not sure. I think that the respondent had another order from the same judge, in some way copied that signature or looked at that signature or maybe even photocopied that signature. The other 2 documents that were falsified, I think they made it appear as though that they were file stamped. Somehow the respondent was able to do that. The fact is that happened on 3 separate occasions. There's no dispute that the respondent engaged in extensive and very serious misconduct. The panel broke it down. There were 16 instances of failure to communicate with clients. There were 14 instances of lack of diligence. There were 10 instances of lack of candor with respect. So you can see, since there are 18 cases and a number of different, that some of this stuff happened more than once in each case. Aggravating factors found by the panel were dishonest conduct, obviously, a pattern of misconduct, multiple offenses, and vulnerable victims. I would like to comment a little bit on the mitigating factors. The panel found that the respondent's depression and anxiety contributed to the misconduct. I have no doubt that happened. And it is good that the respondent has sought and is continuing to receive treatment for that. However, there are some conclusions in the only psychologist report that we have, which is an exhibit in this case. If you look at the conclusions after an extensive report, there are a couple of comments that trouble me. First, with proper treatment, both pharmacologically, I was worried about being able to pronounce that word, and therapeutically, it is reasonable to believe Ms. Kupka can exercise appropriate professional judgment and behavior. Ms. Kupka is still showing notable depressive symptoms despite her current antidepressant medication. The psychologist described the problem as being a major depressive disorder. This report was presented to the panel and is dated in February of 2019, so it's some time ago, but there's no subsequent report. And so these findings obviously are troubling to me if we're talking about the respondent just in 6 months immediately being able to go back into the practice of law without any sort of 219 hearing. A second area of mitigation cited by the panel, and it's clear, I think, to me that the panel felt strongly about this, that the respondent was overwhelmed and overworked, and this contributed to her misconduct. And it's clear when you read the report that the panel members felt that this was somewhat the responsibility of the firm. The panel indicated that although that she received some supervision, some monitoring, that there clearly was not enough. I think it's noteworthy to know that the respondent began with this firm as soon as she got out of law school in 2011. Apparently went to 2015 without any significant problems, and then the misconduct begins in 2015 running through 2018. I'm not sure how much, if you're in a firm for 4 years and you're doing well, I'm not sure how much supervision or monitoring a firm will be required to provide. But my main concern is that when confronted with this overload, the respondent had two ways to go. Either confide in members in her firm and ask for help, or do what she did, which was to hide things, to create things, to mislead her firm, to mislead her clients. She just obviously went the wrong direction. In light of that, and I also would like to read to you just a quick statement from the respondent's self-report letter. We first received a complaint letter from the firm. A few days later, we received a complaint letter from the respondent. In the second paragraph, the respondent states as follows: "The history of my employment and my assignments described by the firm are accurate. Moreover, I would submit that the firm is completely without blame for any of my transgressions herein." The attorney who reported it very astutely notes that in some cases I appeared to expend more effort avoiding the project that was due than it would have taken to complete the task. This is true and undoubtedly another indicator of the depth of my depression. I was overwhelmed to the extent I felt helpless. The pressure I felt for getting tasks done, billable hours, and satisfying any superiors at the firm truly originated from within. I have no one to blame but myself. And when I should have reached out for help, I didn't. During this period, the firm was completely unaware of my lack of diligence and my dishonesty or lack of candor with clients or my failure to communicate with clients. During this time, in fact, in great part because I did not communicate with my supervising attorneys. Seemingly totally inconsistent with what was found by the panel. This is straight from the respondent's mouth. In conclusion, I would say this is not a probation case, as the respondent is requesting. this misconduct merits suspension. I could easily be standing here asking for more than what we asked for, but I think the respondent deserves some credit for what she has accomplished so far. A year suspension with a reinstatement hearing at the end of that time, I think, is completely appropriate. Our charge is the protection of the public. And it seems to me, given the medical evidence we have in this case, and given the respondent's own statements, that there needs to be a 219 hearing after a year's suspension to make sure that there is clear and convincing evidence that the respondent is fit to come back in the practice of law.
Can I
And that's
clarify your recommendation? I thought you initially said it was a 2-year suspension with the ability to ask for reinstatement after 1 year. Is
That's
that what it
correct.
is?
If I said something differently,
I thought you just said a 1 year and then,
oh, well, yeah, I'm sorry, it's a 2-year suspension with the ability to apply for reinstatement at the end of 1 year.
okay, I just wanted to clarify
Yeah,
that. Thank
I
you.
think I misstated that.
Mr. Haslett, and I'm referring this question to her falsifying the judge's signature, do you know if this has been scrutinized or referred to any prosecutor's office?
I do not know if it has.
I'm reading the hearing panel report to be that it was a judgment that was falsified. But all that I see in here is that the judgment was used to hand to one of the attorneys in the firm, I suppose, to show that she did something, as opposed to falsifying the document and then trying to take it out and try to enforce it or something.
That's correct.
Like that. Is that true?
I believe it was to show somebody in the firm that she had obtained that relief, not that she was going to try to enforce it in court.
What's the ethical responsibility of the other attorneys in the firm for supervising people?
What was their responsibility? Obviously I think the panel felt like there was some responsibility, but in her own words, the respondent was saying that this was my fault. I was hiding this from everybody in the firm. And again, I go back to the fact that she was there for 4 years doing pretty well. And then, I mean, if you read the testimony, I think she indicates that she took over some work from other folks in the firm, somebody who left the firm, and that the load just got to be too much.
Well, didn't the nature of her practice change after that initial period when she was doing collection work? And
It did change. It did
And then
change.
switched to like insurance defense work,
It switched to some of that, and I think to domestic relations as well.
you know.
But I think there were also some responsibilities that were taken away from her at the time when things sort of switched.
No, I don't suggest otherwise. I'm just, the nature of the practices becomes different. The skills, what you have to do is run a collection practice may be quite a bit different from,
Absolutely, and if you don't know what you should be doing, you should ask,
right.
because you're in a firm.
I guess I was a little concerned about the remedy you propose with the reinstatement and hearing and all of that, because it seems like the 2-year suspension becomes a 2-year suspension even if you're asking for I suppose you'd be reinstated a little faster, but you're going to serve a good chunk of the 10-year or the 2-year suspension before you make it through the hearing process and then back up to here and then on your way.
I agree, Justice Miles. The application for reinstatement can't be filed until you serve the suspension, so it does take some time to.
I suppose your approach is still giving her 9 months or a year earlier back to practice, because a 2-year suspension with reinstatement would have 2 years plus the processing time, so.
True.
Okay.
I will say, though, that, I mean, if we have a reinstatement hearing, I mean, we don't have to docket it and come back here and argue it again. I mean, you decide based on what the panel sends to you and what their recommendation is.
and give us some idea again, because it does fluctuate. If we were to impose your sanction, what's the realistic time frame after 1 year that a reinstatement hearing would be had?
Well, we have really tried to speed it up because this has been
I
an issue
understand.
that's come up
Right.
a number of times, and I
So we're
understand.
kind of where you at now?
Well,
Just give us some.
we have a
idea.
couple that are going on right now, some reinstatement hearings, and I think we've done those pretty quickly. I think that, we have a questionnaire that we send out that we ask
What's
the
pretty
respondent to
quickly?
fill
Just
out.
give us an idea.
Well,
I don't,
I'm
are
talking
you
so
talking
that
a
I can-
month, 3
so that I
months,
can
6 months?
Come up with it.
Or no, what are you talking about?
I think we would like to, from the end of the suspension period, to have a hearing within 3 to 4 months after the suspension period.
Okay,
Is
that's what I want to get an idea. Thank you.
Okay.
Thank you.
May it please the court. My name's Trey Petlin, and I'm appearing with my client, Laurel Kupka. With regard to the fabricated documents, there were 3 of them. They were documenting the file, the firm file, her file, so that in case her supervising attorney reviewed the file, her supervising attorney would believe that she had done whatever that project was. And in her mind, there's obviously no excuse for that, and we're not here to make any excuses. In her mind at the time, what she was thinking was that it would buy her time to get the project done if she needed to do it. And that was her intent, was that if the file was inspected. The pleadings were never disseminated to the client. There was no indication they were disseminated to any other third parties. In fact, it wasn't even clear 2 of the files were closed, whether anybody saw them, but we can presume that that information was conveyed at some point to the supervising attorney. It was different in each file. She had multiple supervising attorneys depending on what kind of case it was and during what period it was. The hearing panel's recommendation turned on the general principle that probation is not an appropriate discipline in a case involving dishonesty because it does not provide adequate safeguards to protect the public. And as you can see, the hearing panel cited to In re Stockwell, 296 Can 860. This court noted in Stockwell that it is generally reluctant to grant probation where the misconduct involves dishonesty, quote, because supervision, even the most diligent, often cannot effectively guard against dishonest acts. I'm asking the court to diverge from the panel's recommendation of suspension, which is predicated on that principle. And I would submit that this is an exceptional case for a number of reasons. In part because there is compelling evidence that was presented to the hearing panel that the dishonest conduct was completely out of character for my client, and in part because the cause of her dishonest conduct is identifiable. Severe, undiagnosed, untreated depression that caused her to act out of desperation, out of hopelessness, and out of a sense of being overwhelmed. In its discussion of respondent's dishonest conduct, the hearing panel observed that her conduct was, quote, triggered by her overwhelming caseload, lack of direct supervision, and her depression, end quote. Additionally, I would submit that probation is a viable option here because the last transgression was nearly 2 years ago. 2 years that she has had to invest in herself and to engage in treatment and education. So I would submit that the unique circumstances here make probation a probation plan workable.
What has your client been doing in the last 2 years in terms of her work?
In terms of work,
Yeah.
she is now working in a 2-person firm. She's limited her practice even more than our probation requires, so that it's only family law and it's only in Johnson County, Kansas. And the reason for that was that it's easier for her practice supervisor to monitor that because she, with the press of a button on the GIMS system, the Justice Information Management System, her practice manager can see how many cases she has. She's also on her, anytime my client would file something, her practice supervisor would get an e-notice from the electronic filing system. But to this point, from our hearing, she's not the principal attorney of record in any case. Her practice supervisor is. So that's what she's been doing.
Counsel, let's extend that question since the hearing report in October to the treatment and medication regimens and that kind of thing. Bring me up to speed on that.
So she's maintained her as a patient under psychiatric care and taking medications. Her medications were increased after Dr. Capo's assessment. Her antidepressant regimen was increased, and she's on that. She's very comfortable and as she said, happier than she's been since law school. She's also seeing her counselor, Mary Sheridan, on a regular basis. I would have her address that a little bit. And she's in her second year of her KLAP agreement. So she just renewed that, I think, a couple of months ago. She meets regularly with her KLAP monitor. She gets a great deal out of that. I thought it was extraordinary that in the same discussion with Ms. Kupka's dishonest acts by the panel, that they made a point to evidence that her spiral downward stemmed in part from her, quote, selfless conduct, end quote. They didn't discuss selfish motives or selfish conduct. They discussed her selfless conduct. And of course, they were referring to her inability to say no to additional work and her inability to even express that she was overwhelmed and could not handle any more. Dr. Capo's assessment, which was extensive, noted that even after she started, just to extrapolate on what Mr. Hazlitt said, even after she was administered antidepressant medications, her main depressive scale was more than 1 standard deviation over the mean, and her demoralization, which is a measure of severe discouragement, was nearly 2 standard deviations above the mean. Of the 19 cases that were examined and reported by the firm in the complaint, cases that go back to 2012, 12 of those 19 were when Ms. Kupka was pregnant in the last part of 2017 through her maternity leave, March 1 of 2018, when her depression was deepest, when she was overwhelmed. 2 of those files were opened on the same day, just as an anecdote, August 30, 2017. 4 of those 19 files were in 2015, which was during her second bout of depression, but her first significant bout. It became debilitating at the end of 2017 and until her maternity leave in March of 2018. So that leaves 3 of the 19 files, and the 3 files out of those 19 occurred at times that were not marked by notable depression. And the issues in those 3 files were diligence and communication. There were no honesty issues. The hearing panel was presented with significant evidence that Ms. Kupka's dishonest conduct was motivated by her emotional inertia, her feelings of being overwhelmed by the number of files, and her deep depression, as well as her fear of disappointing others, including her clients and other attorneys in the firm for whom she has a great deal of respect. Obviously, the best gauge to understand, what can we do for somebody who is struggling with depression is very, very difficult. Anyone who has loved ones who have depression know that. If someone is lying or being deceitful because they are mean-spirited or they're selfish or they're trying to swindle someone or they're malicious, then I would submit that the general principle that probation is not an effective safeguard for the public is sound. But when probation can be workable, I would submit, is when you've got somebody who is a really good person by all measures, for whom dishonest conduct is outside their character, and that root of their behavior is severe depression. And it can be isolated that way. People who have loved ones understand, people who have loved ones who are depressed understand you can't just shake them and say, snap out of it. The firm's meeting in late February 2018 was essentially an intervention. If this hearing was in March of 2018, probation undoubtedly would not be an adequate safeguard. But respondent has had almost 2 years to grapple with her depression, the cause and effects of it, and to improve her life. So a probation in 2020 that successfully addresses her mental health needs and places a practice supervisor around her who knows what's happened and understands her mental health, who is in a position to monitor her practice closely, can provide adequate safeguards to protect the public and ensure that the respondent complies with her probation. Especially, again, considering the most recent transgression is nearly 2 years ago, and she's been treated continuously since then. Her counselor noted in her report for the panel that she had made a commitment to treatment and education. Another letter that was submitted to the panel described it as a tenacious commitment to recovery. And I would submit that now a probation here would not be rewarding bad conduct. It would be rewarding someone who's managed to pick themselves up off the floor. It would change the focus to rehabilitating someone for whom there are significant mitigating factors, as the hearing panel noted. Someone with a treatable mental health issue and conduct that is not grounded in selfishness or a desire to harm others. It would further recognize, I think, to some extent, a mental health crisis in the profession. We have 2 letters from former associates of hers at the firm that are glowing. A wonderful letter from a law professor and other attorneys who have known her for many years. And they described her in glowing terms: the highest character, honest, reliable, trustworthy. And one of the best things you can say about anyone, she has a good heart. Ms. Kupka was not using dishonest conduct as a malicious means to harm her clients. The panel described the harm to clients as potential harm in instances where there were any harm, it was delay in the resolution of the cases. No client suffered financial harm, unlike the In re Mason case. The firm did a thorough evaluation of every one of her files, past and present, and wrote in the complaint that no clients were harmed to the best of the firm's information. And if there was any harm, the firm worked to correct it. But the firm was not talking about financial harm to clients. There were cases that were not resolved by the time my client took her maternity leave, which was early. They simply weren't resolved. Traffic tickets that were scheduled in the future. There was an eviction case which they finished. There was no financial loss to the client. It was an eviction of people that were squatting in the client's barn. There was one other matter involving a basement where the firm, after my client took her leave, decided that the case wasn't worth pursuing. And the client was a good client who brought them other business, so the firm decided to just pay the client. They discussed what the case would have been worth. It was in the early stages. The file was opened at the beginning, I think the end of September 2017, and my client's leave was March 1 of 2018. There was nothing that my client did that prevented the firm from pursuing that, but they chose not to, and they paid the client $3,000. They wrote off $800 in bills on another file and paid $2,200. And when my client found out about that, my client paid them the $3,000. And they agreed they weren't expecting that. The attorney who testified at the hearing panel did not consider that restitution. That was a business decision that they
Counsel, I
made.
don't know if you intended to have your client speak, but you're.
I'm sorry. Yes, I do. Thank you, Madam Justice, Chief Justice.
Morning. May it please the court. My name is Laurel Kupka. I'm the respondent. I regret what I did. There won't ever be a bigger understatement in this courtroom. But since the time that I started my maternity leave in early 2018, I've gone from devastated, can't breathe, uncontrollably crying, devastation, to understanding and even appreciation. Still crying, as the court can see, so I apologize. I'll try to get through this as best I can. I'm very grateful for this process and for the opportunity to address the court today. I make no excuses for my behavior. My actions then are very appalling to me, but at least I can understand them now. There is a concept related to severe depression called the impossible task. The impossible task could be anything, and it is often the smallest of tasks that suddenly, for no apparent reason, seem completely insurmountable. It's often something you've done hundreds of times, and you start to beat yourself up over what a screw-up you are for not being able to do this very simple thing. It becomes a vicious cycle, and you feel paralyzed. Many of my transgressions began with an impossible task: returning an email, filing a document. To someone on the outside, there is no reasonable explanation for this behavior. I never intended to harm anyone and never intended to gain anything. It was always my intent to try to make things right, but I now understand that you cannot do right by doing wrong. I don't blame anyone but myself. When I was overwhelmed, I did try to hide it. I was embarrassed, and I didn't have the strength or the tools that I needed to ask for help. At that time, I was committed to not disappointing anyone, even when it meant saying no to a project I didn't have time for, or admitting that I was overwhelmed. Feelings I'd had before in my life became amplified during my pregnancy, and I was my own worst enemy during that time. I hid my depression behind my smile, and I appeared to shoulder my responsibilities with a lunch pail attitude because that's what I always did. I always prided myself on being driven, on being a perfectionist. I could always do more, I could always do better, my best was never good enough. These qualities served me well in school, but had become very toxic for me. The brain is amazing. It can do things that are incredibly good and things that are incredibly bad. My brain convinced me that I was worthless, that I was a pathetic failure, and that no one cared. It made me believe I would be judged harshly by others for what I perceived as my weakness and my inability to complete simple tasks. I offer this explanation to the court not as an excuse, but to show the court what I have learned. This process has required me to confront my own humanness in a very unique way. I've gone to a place of deep remorse in my heart. I broke down whenever I spoke with my attorney and during my panel testimony, and I'm breaking down now again, I apologize. It's been very difficult for me to discuss, and I'm trying my best to get through it today. I've done quite a bit of work over the last 2 years to not only understand myself, but to learn to be mindful and intentional in my personal and professional lives. I've learned to share the load, to acknowledge and express my feelings, and to admit when my plate is full. Asking for help is not a sign of weakness, it is a sign of great strength, and so is allowing yourself grace. I was asked a question during my panel testimony that I would like to address today. When discussing the proposed probation, the panel wanted to know what would happen when the probation was completed and someone wasn't looking directly over my shoulder anymore. As I told the panel, this is bigger than my license and my ability to practice law. I understand that I have to prioritize myself and my health, not just because I want to be a good attorney, but because I want to be a good parent, spouse, daughter, and friend. I've even voluntarily reduced the limited scope of my personal practice to only family law in Johnson County. And as Mr. Petland indicated, I'm not currently attorney of record in any case in Kansas or in Missouri. I have found ways to structure my day and my schedule to keep my practice manageable, and I have plans in place for when I'm confronted with what feels like an impossible task. I understand my behavior, and I've been working to correct it for almost 2 years. To be completely candid, I will continue to take all of the same steps regardless of whether or not they are required by any probation plan. Nothing can or will correct my behavior but myself. I have to treat this condition just as I would if I had diabetes or high blood pressure. I have to be conscious of feelings of anxiety and depression and take appropriate steps to address those feelings. I don't think of this as just embarrassing, it is humbling, and I welcome that part of this process. I've done a lot of reflecting on how I let things debilitate me and how I got to this point. I've met and talked with intelligent, caring people who have wanted to help me, people I'm very grateful to know. I've learned about my depression and my vulnerability, and it's only scary when you don't understand it. I have also learned what it is like to be on the client side of the legal process, which is another experience for which I'm very grateful. This experience has helped me relate to others on a new and different level. I hope that others will see my actions and understand that they are not reflective of my character, that they are actually contrary to my character. I deeply regret that my past accomplishments have been overshadowed by my failures. I am immeasurably thankful for the unwavering support of my family, Ms. Carmody, my supervising attorney who is here with me today, and Mr. Petland. They have reminded me, and the very kind people who wrote character references have reminded me of the many good qualities that I possess, which I had long since forgotten. I do not want to go back to the dark, negative place in which I lived for so long. I truly did not realize how badly I felt until I finally began to feel better. I can look back at my past and identify dark times, and I wish I had learned to name anxiety and depression sooner. What should have been one of the happiest times of my life, my pregnancy, was without a doubt one of the most terrible in such a way that it's difficult to put into words. But going through that has brought me here, and my life is so much better now than it was before. I was given time to focus on myself, to heal, to enjoy time at home with my baby, and I have a loving family, a supportive husband, and in my totally biased opinion, the coolest, funniest toddler in the world. I have found a tremendously nurturing work environment that has rekindled my interest in the practice of law. And I've said this many times, I hate the way that all of this happened, but I will be eternally grateful that it did. That concludes my remarks, unless there are questions. Okay.
Counsel, if you would like to succinctly summarize with your request to the court.
Thank you, Judge, Justice. I am asking that the court grant a probation based on the arguments that I described that I think characterized this as a unusual case, and specifically the powerful mitigating evidence. So I'm asking for a probation for 2 years under the conditions that are described in the exhibit that was submitted to the panel. In the event that the court does not agree with me that a probation is workable, I would ask the court to consider the suspension recommended by the panel, 2 years with probation after 6 months, without requiring a reinstatement hearing. In Stockwell, the case that was cited, this court observed that the respondent questioned even the need for the probation, and that was a significant factor in the court's decision to require a reinstatement hearing. And I'd ask the court to give her an opportunity on probation, give Ms. Kupka a chance on probation. Thank you.
Thank you, counsel. Mr. Hesler?
Just a couple of things. I want to confirm what Mr. Petland said. I don't believe there was any financial harm to any client. In 14 out of the 18 cases, the panel found that there were diligence issues. And as I was sitting over there, I read the comment to Rule 1.3, diligence, it says perhaps no professional shortcoming is more widely resented than procrastination. Goes on to say that even when the client's interests are not affected in substance, however, unreasonable delay can cause the client needless anxiety and undermine confidence in the lawyer's trustworthiness. Got to think that did happen. One other thing that's in the record, the managing partner, who was the complainant in this case, indicated that the firm spent about $125,000 worth of lawyer time in making sure that there was no financial harm in these cases, and making sure that the client was satisfied despite what had happened in these cases. So I would just ask the court to take that into consideration. It's an emotional thing, obviously, and I was very impressed by Ms. Kupka, but the fact is, I don't know that, in my mind, that the evidence is there that I could possibly recommend that Ms. Kupka come back into the practice of law after a suspension without some sort of reinstatement hearing. I'd be happy to answer any questions.
Thank you, counsel. Thank you to both counsel and Ms. Kupka. The court will take this matter under advisement at this time.